There's a good chance someone you deeply care about, a child, a grandchild, a niece, a nephew, a sibling, or even a parent, has special needs. By that I mean a cognitive, physical, or even behavioral impairment that now or in the future may permanently impede them from gainful employment and financial self sufficiency. What can you do to help these loved ones have sufficient resources throughout their lifetimes without disqualifying them for any federal or state assistance for which they otherwise might be eligible? To help us explore this question, today we've invited special guest Kenneth Piercey. Ken is an attorney from the Chicago area who specializes in tax-smart estate planning, special needs planning, and business succession planning. Stay tuned as Ken helps us understand how to better plan for our special needs loved ones right now on the Retirement Lifestyle Show.
Welcome to the Retirement Lifestyle Show. I'm your co-host, Roshan Loungani, here with Erik Olson and Adrian Nicholson. Today, we're really excited. We have a special guest joining us, Ken Piercy. And Erik, I'm going to let you introduce him and start us off.
Absolutely. Well, first of all, Ken, thank you so much for coming today. And for our listeners, Ken is someone I've known for, Ken, I think it's been, I don't know, I'm guessing it's been about almost 15 years, possibly. It's been a long time. So
that sounds right.
And way back in the day. So Ken Piercy practices law in Barrington, Illinois, which is about 30 minutes from where my office is in Crystal Lake. And Ken has a practice that focuses on estate and trust law, tax reduction, long-term care planning, special needs planning, and business succession. And so he is part of a firm that covers a lot of areas. And I think, Ken, I've noticed that your firm has really started to build out also in the real estate area lately, which I don't know if you're practicing in that area, but that's, just there's a lot of capacity, at least within your firm. And so the scope of Ken's work has included representing clients with over $1 billion worth of assets, multiple lottery winner clients. That's a story I'd love to hear sometime, Ken. And has also worked on some of the really most complicated probate cases involving deep complexity around heirs, as was stated by one of the Cook County judges who deals with this in the probate court. So Ken's also, I know this because I see you, Ken, from time to time at these conferences, one of the few attorneys out there who has gone to the trouble of getting the Certified Kingdom Advisor designation. And so I think, Ken, if I'm not mistaken, are you the only one in the state of Illinois, actually the only attorney who has that designation?
I think so.
So I think that's fantastic. So for those of you who've heard me talk about that designation, and I have as well, it's a nonprofit group that's focused on how do we have both tax, legal, and financial advisors bringing sound biblical advice to their clients. So in addition, Ken has been an expert witness on a variety of cases, including trust interpretation, a murder trial by jury, and has been published in the Illinois State Bar and National Business Institute, has been a wide-ranging lecturer to other attorneys, CPAs, IRS agents, as well on the subject of taxation of trusts and tax reduction strategies. He's been quoted by the Daily Herald, one of the bigger papers in the Chicago area, featured on the AM 560 radio station there, and recognized by the Chicago Tribune, Wall Street Journal, American Lawyer, the National Law Journal, and Corporate Counsel magazine. So, Ken, kudos to you for all of that. That sounds like a really interesting career, and given how young you are, may you have many decades of such interesting times ahead. That's fantastic. So, yeah. So, Ken, what we really were excited to talk about with you today was the subject of special needs planning. And for our listeners, we just want to say, we all have, when I say we, Adrian, Roshan, and I have clients that have, and Ken undoubtedly you as well, have clients that have, let's say it's a child, it's a grandchild, it's a sibling, or someone in their sphere of loved ones who is challenged at one level or another, whether it's cognitively, physically, whatever, and doesn't have necessarily the capacity to proceed through their lives and establish a way of making a living for themselves, and on and on and on. And so then the question becomes, how, and out of our love for these people, do we care for them in a way that's wise and that takes advantage of both the opportunities for where benefits do exist from the state to help with this as part of the larger social contract, but also at the same time not position these loved ones to be either in a situation where they either are denied access because we've over provided for them in some ways, or we've gone about it unwisely, et cetera. So, Ken, big topic for us, and increasingly sort of awareness around all of this. Tell us, how would you define special needs planning?
That's a great question. So I would describe and define special needs planning as creating a plan for someone with special needs. That's a very generic, easy, simple definition. Um, but special needs could be anybody who either has difficulty working or is disabled, either mentally or physically. Usually, somebody who qualifies or might in the future qualify for any kind of government benefits, Medicaid, supplemental security income, Social Security disability income, sometimes VA benefits. So it's really just strategizing with professionals to come up with a plan, both, while alive and after. Typically there's a donor involved, some like a parent or somebody who's typically charged with the duty of taking care of them, or maybe they help out. So just creating a plan so that that help can continue after the donor becomes incapacitated or passes away. That's how I would define it.
Mm-hmm.
Now, how many people does this? How many families? I think I'd seen once that said about a third of families are impacted.
Yeah,
Is that accurate?
that sounds correct. Yeah, I think it's about a third has some family member that has some sort of special needs. Exactly.
And Ken, interesting. My wife was telling me this morning that she had been doing reading about the impact, the larger impact that having a special needs child in particular, I don't know if it extends out in equal proportion to other loved ones who have a special needs, but at least if there's a special needs child in the family, that the incidence of divorce among those couples skyrockets. It's something like, and I don't know if you have a number, but she was citing a number that said about 90%. So the don't clients or listeners, please don't quote me on that. But I mean, some outrageously high impact on the divorce rate. Is that something you've seen or are aware of?
I would say it's definitely much higher in my experience. I have many clients who have special needs children, and it's just so much more difficult to live life.
Mhm.
And it's just always it's kind of almost like a full-time job.
Mm-hmm.
That doesn't stop. So it's a big responsibility with many challenges.
Well, there was one question that I wanted to ask, and then I'm sure we're going to mix it up a lot here. But a lot of times, I think people have the mistaken assumption when they hear this about any form of estate planning or any planning related area, that it's a fairly static area. And my perception is that some of these areas are not so static. Would you say that special needs planning is sort of in the same spot it was maybe 10, 15, 20 years ago, or have the strategies and sort of the legal framework, has it changed in any way that would, even if someone says, oh, I did that 10, 20 years ago, I don't need to do it again, is there are there is there a framework now that would help them if they revisited that plan?
That's a great question. So there have been several changes, to the laws, governing government benefits and special needs planning. The most recent one that I can think of is dealing with the Secure Act with regard to retirement accounts. And, there is an exception. The general rule after someone passes away is you can stretch out their inherited retirement account for 10
Mhm.
years. There is an exception in the Secure Act for disabled beneficiaries. You can actually do a lifetime stretch over the course of their entire life. So creating a plan around those new rules is one of the newer issues that we see presenting itself. And there are some powerful strategies to basically make it so that the retirement accounts can be tax deferred as long as possible, and the non-retirement accounts can perhaps go to non-disabled beneficiaries, the net result, obviously, a lower tax for everyone involved.
Mm.
So, as you're the expert in tax deferral, generally speaking, tax deferral is a really good thing. So that can be built in to existing planning and special needs planning, is if there are retirement accounts that are going towards this beneficiary or towards the family, just being aware of that issue. And there have been other issues as well. There was some new trust statutes. I practice law in Illinois and Wisconsin, so there was some new trust statutes adopted in Illinois recently that changed some of the language with regard to special needs beneficiaries. One of the issues that we see sometimes is if you have a beneficiary of a trust and it's usually limited to just needs like health, education, maintenance, support, common language you would see in an estate plan in a trust, for example. It used to be that language was very problematic and could disqualify someone. Now, some states have passed laws to make it so that language is acceptable. So just being aware of, a lot of the pitfalls and the new law changes is really important. But in your time frame, 10 to 15 years, I would say, it's never a bad idea to have general planning looked at from an estate planning side, every 5 to 10 years or so, or more frequently if it was prepared by someone who doesn't focus their practice in, estate law, estate and trust law. And you had asked me earlier about, what the other real estate law areas. I just focus in estate and trust law and those related areas. But we do have other attorneys that practice real estate law.
Well, I want to amplify the one point that you just made, and this is not a knock on attorneys that have multiple areas of focus in their practices, but I do think that there are some things that you just really want to get right, and it does pay to work with an attorney who specializes in this particular area. I think I don't want to venture into every area of law, but I would certainly say in the categories of estate planning and special needs planning, it really does pay to work with somebody who does this sort of thing day in and day out. So for our listeners, irrespective of who you're working with, I do want to just say, if you had used a generalist to develop your estate plan or your special needs plan previously, you'll probably be well rewarded if you visit somebody who sit down with somebody who specializes in that area to do a review. So Roshan, Adrian, what questions have you got?
Ken,
Yeah, I'd be happy to.
Ken, I was actually
go
going
ahead,
to
Roshan.
say, well, because Adrian, I'll let you go next. What you just said is so important with the law change, right? Because I'm thinking specifically about a client that has multiple kids, and their goal is to pass it equally to their kids. Well, it makes sense instead of taking all accounts and say, 25%, they have 4 kids, 25% each, that you weight the retirement account to the special needs child because they can stretch it out for the lifetime versus the 10 years. So that's just to sort of echo what you said, having an expert in the field, or what Erik said of having someone who focuses on this, because it'll just help money last longer, right? I always say to clients, the money you've saved, they want to make sure it goes to their heirs more than taxes, typically. But Adrian, please continue.
Yeah, I think some of our listeners would kind of want to understand a little bit more about the special needs planning process. Like if they were to have like a conversation with you, what would it kind of look like? If you could maybe share like a story or an example, like a very successful story of some people that you met that set up a special needs plan that worked really well, or maybe the opposite of they already had a plan in place and maybe you took a look at it and you say, hey, maybe this is some stuff you could have adjusted, or this is something we maybe should have changed with the plan that is commonly used by some people, but isn't really a great strategy.
Yeah. So I think what I'll do is I'll start with what got me really thinking about this about, 11 years ago when the issue kind of first presented itself. A client came to my office. I'll start with what I've seen go wrong, and then I'll finish with, how that can be addressed well or better. So in around 2011, I had a client come to my office. She was on Medicaid. She had a rare form of skin cancer, and she had told me her medical treatment was over $200,000 every year in costs, and she called it life-saving treatment. Now she was, I think about 55 years old, and because of that big cost, she had to spend basically all of her own money. She had to spend it first on care, and then once her assets were diminished, she was able to qualify for state Medicaid, and the state Medicaid office was paying for those costs, which is a great benefit. That's the idea behind Medicaid in general is if you have your own money, pay for it. The general rule is $2,000. If you have more than $2,000 in assets, then you have to spend your own assets. There are many exceptions, but generally. So she came to me because she was inheriting money from her deceased father. Her share was about $500,000, and her father's, it was a probate case. The estate plan, the will basically said to my daughters, equally. There was no provision in there in the document about special needs or anything, and she was able to work, but can't keep up with the costs, for that scenario. So long story short, she basically was had very difficult options. When she inherited the money, it's a disqualifying factor for Medicaid because it's more than $2,000 that hits her account. She actually had a daughter. She wanted to disclaim the inheritance so that it could go to her daughter, but Medicaid, we researched it at the time, it would have been treated as a gift. And Medicaid looks back 5 years for gifts. So the long and short of it is her options were very limited. There was a payback trust option, but it ended up having to pay back after her death, to the state for the benefits that they had provided, which, as you know, are substantial in that case. So, bottom line is the money had to basically be spent on her care. So that's kind of what can go wrong without planning. The money was basically gone and much more accelerated. The way to address that from an estate planning perspective is to say, if your child has a special need, or qualifies for government benefits, you can actually carve out and say this particular child's share goes to a special needs trust, and it's carefully drafted so that they can stay on and obtain the government benefits, but the benefits that are not provided for by the state or the government would be available for the beneficiary. The most common would be the luxuries, extras, vacations. Sometimes people need warmer weather or dry things for lung conditions. So all this stuff, there's also entertainment expenses, so all the stuff the government typically doesn't pay for would be available as kind of the rainy day fund or emergency fund. And then you have a person in charge, typically the trustee, who would be able to, get advice from financial planners and accountants and attorneys to make sure that it's handled properly and there's no disqualification. And then you can really maximize the benefits legally available. So those are kind of the two stories, the main one being preventing disqualification from the benefits that can be substantial in my example here. But that's a great question.
Following up then on what Adrian just was asking, so how is that process going to start? They reach out to you, they set up a meeting, they sit down and talk with you about the case, and at that point, what comes next?
So the process is typically to start by scheduling a meeting, calling or emailing, an attorney's office. We offer a no charge meeting where we kind of go through the situation, take down the information, ask the client's goals. I typically ask, after we figure out who the beneficiaries are that they want to name in their plan, I typically ask, are any beneficiaries, do they have any special needs? Are any irresponsible? Are there any that have any bankruptcies or judgments against them? Just kind of trying to fact find. And, if a beneficiary has special needs, then I typically ask what kind of benefits, if there's a disability, what kind of disability is present. Sometimes people are able to work now, but they have a medical condition where 10 years from now, they won't be able to, and they'll qualify for benefits. And typically the rule is, Social Security, if you work in for 60 months, if you pay into the system and pay taxes for 60 months, then you would qualify for some sort of a benefit. So to answer your question, we typically, the first step is to meet with an attorney who understands these rules, who practices in estate planning and understands special needs, and basically create a plan, also figure out what kind of, help is currently being provided by the family or the friends or the church or the charity, so that can be continued on, after people aren't able to help out. Because we're all kind of ticking time bombs. It's only a matter of time before we're not going to be here anymore. So just planning ahead for that eventuality, even though it's, most people don't think in those terms. I'm a somewhat of a very long-term planner. I'm always thinking about, well, what happens when I'm not around? What happens when everyone else is? Because it's, from my perspective, 50 years isn't necessarily a long time. It is for me individually, but not in the grand scheme of things.
So, Adrian or Roshan, I've got many, many more questions, but you go ahead. What's next for you?
Well, you described people coming in and setting things up and law change earlier. How dynamic is this process? Should someone, when they come in and set something up, are they reviewing this annually? Is it every 5 years? I imagine it's not a one and done situation.
That's a great question. So I'll start by saying that if the attorney that prepared the estate planning documents doesn't spend at least 80% of their time in estate planning, my recommendation would be to have it reviewed. I offer a no charge review of for potential new clients, no charge meeting where we go through the documents in fine detail and then report back. We have a checklist. We actually have a trademark on our trust. We cover about 20 to 30 items that often go unaddressed. So just kind of, if it wasn't somebody who if the professional was not, if they didn't focus their practice, have it looked at. If it was a professional, our recommendation is every 5 to 10 years, have a conversation, have a legal audit conducted, so that I's can be dotted, T's can be crossed. There were, as you know, the Secure Act changed a lot of the rules with retirement accounts. So that's the short answer. The more advanced kind of answer is there is something called a trust protector that we include in our estate plans because the laws are ever changing, and the laws changed so much in the last recent years. It used to be every 5 or 10 years. Now it seems like every 2-3 years there's a law change. So I was kind of asking myself, how do I prevent my clients from having to get an audit every 2 or 3 years and pay legal fees? So what we've done is we created this trust protector that I mentioned that allows a trusted party, if the laws change many times so let's just say I create my estate plan. The laws change 3 or 4 to 5 times, and then I pass away, and I never updated it because I didn't want to spend, whatever legal fees it would have been. The trust typically becomes irrevocable upon death. And now we're stuck with a potentially outdated document. And with retirement accounts, for example, if you were to ever run retirement accounts through a trust, the trust has to be carefully drafted. If they're, with the changes in the laws, we want to avoid tax pitfalls. So we don't ever want to find ourselves in a situation where, I wish the trust said this. We could save, $80,000 in taxes over a 10-year period if the trust had only been written differently. The prior solution to the trust protector was to have to go to court typically to change the terms, and we weren't always able to get a judge to see the wisdom of, lowering taxes for beneficiaries. So the trust protector, in summary, allows a trusted party to change the terms of the trust after death. It's irrevocable with respect to the person who created it after death, but the trust protector can make an amendment for the benefit of the beneficiaries. Typically, the trustee and the trust protector have to agree that it's in the best interest. We don't change shares around. That would obviously be not allowed. We wouldn't want to do that. But the provisions, the terms, changes in the laws, ambiguities, the ability to correct things that might have been missed, that is the idea behind the trust protector, so that clients, if that's done properly, clients shouldn't have to feel like they need to update it every time there's a law change. And really the only time they would need to update it would be changing in shares, like, I want to give 10% to charity, or I want to give money to this person instead. That's typically would be required to amend the document, involving we would recommend a lawyer. But law changes, that the trust protector goes a long way to reduce the administrative costs of having to feel like a client has to update the documents every 3 to 5 years, or even every 2 years most recently in the last few years. So that's the long answer. You can edit that out later, whatever you want to. Sorry.
So, Adrian, I've got questions, but is there one that's on that you've been waiting to ask?
You can go ahead, Erik.
Okay. Yep. So you mentioned both some mistakes that you've seen and some successes. So, and you told a story for each of those, Ken. But if you were to say, just making some broad generalizations about some of the biggest mistakes that you see people recurrently make as they approach this, and trying to provide for their special needs loved ones, what are those kind of recurrently biggest mistakes you see over and over and over again?
That's a great question. So I would say a big mistake would be, I mentioned it before, not working with someone who focuses in a particular area of law. So I mentioned that. Secondly, also, I would say not involving professionals. So, going to the estate planning lawyer and maybe not getting financial advice or accounting advice. I always recommend, get legal advice, get financial planning advice from a licensed financial professional, get accounting advice from a licensed, CPA or someone who's licensed to practice accounting. But that's a common mistake I see. People who think they know, or they think they know enough. That's when it can get really dangerous. So my advice is, involve professionals. It's, in my experience, it's totally worth it. Totally worth it to involve professionals. Another mistake would be maybe overcomplicating things. Sometimes people maybe try to put their own lawyer hat on, and generally speaking, I can handle complicated, but in practice, generally speaking, the two most important things are simplicity and clarity. Providing a clear plan and not overcomplicating can go a long way to make it a lot easier to administer later, the plan. Flexibility is really important as well. So maybe creating in flexibilities when you could have flexibility instead. So I mentioned the trust protector is a way to continue flexibility. A lot of trusts become irrevocable after one spouse passes. If it's a joint trust, unless there's a really good reason, you generally want the surviving spouse to be able to have the ability to make changes as well. So that's a common issue as well.
And the examples that you just gave, Ken, are, I would say, mostly ones of those that actually do take the step of pursuing a conversation with an estate planning attorney. So, but I'm sure there's, many that just for whatever reason think that they can solve it in some different way. What are some of the ways that you see people who just say, I don't think I need an attorney to take care of this? What are some of the things that you are aware of? And you're not seeing it in your practice because those are the subset that do come to you. But for those that don't, what are sort of the gumption traps that they run into over and over again?
That's a great question. I can give you some specific examples. So, I have seen people kind of try to do their own estate planning. So not to get too technical, but generally speaking, if someone passes away and they own real estate in their name alone, typically that has to go through a court process in order for it to be distributed. So trust is, in my experience, the most common way to avoid that for most clients that I serve. Sometimes people get creative and they think, I want to avoid that. Joint tenancy is a temporary fix. Sometimes people title their homes in joint tenancy with their children. That does actually work to avoid probate, but the main disadvantages of that strategy, the kind of do-it-your-own strategy, is if a child were to get sued or go through bankruptcy and their name is on the title, then the parent, who titled the children's name on the house, all the joint tenant holders, joint owners of that property are jointly and severally liable. That's a legal term. It means that the parent could lose the house, and to a judgment creditor. It's, there's exceptions for primary residence and married couples, and you basically triple the liability if you have three owners on a piece of real estate. So that's one example. In addition, typically real estate goes up in value over time. So if I were to have a house that I bought personally 10 years ago, and let's just say I paid $200 for it and it's worth $400,000 now, that's $200,000 in gain. With a will or a trust, you get a full step up in basis. You avoid all capital gains tax upon death. But if you do joint tenancy, then it's deemed to be a gift of half while you're alive. So you lose half of the step up in basis. And there would likely be a capital gains tax of about 10%. It's 20% total, but you would lose out on half the gains tax. So, that's like on a $200,000 gain, that would be potentially a $10,000 tax. So that's one example that could be avoided with proper planning. So the kind of do it your own usually has tax pitfalls, or potential IRS audits that come back later to trigger taxes that people didn't even know were issued.
And you're saying it's sometimes the case that parents will do this in order to take care of those special needs children, that they'll make them joint owners of their own homes. Am I understanding that
Sometimes, yeah.
correctly? Hmm.
Yeah, they're oftentimes not aware that, a person really shouldn't own assets in their own name. Otherwise, they would lose those
Hmm.
benefits. That's
Hmm.
exactly right.
And kind of follow up to that question, are there people you see or scenarios you see where people um, don't actively choose to not get the special needs trust? They just don't know that they really need it, right? So they were, in retrospect, they would have been better off with that trust being set up.
Yes, I do see that, and that's why it's so important to meet and discuss, because there are many times where children are actually fine now, but they have either a hereditary issue. One issue I wanted to mention, it's not that uncommon for there not to be any special needs beneficiaries when you create your estate plan. And then fast forward, 20 years, you might have a beneficiary in their 70s who, is in skilled nursing, and then they inherit their share, and it immediately disqualifies them. So we do actually recommend that there's a clause in someone's estate plan that says any beneficiary who qualifies for government benefits. We don't have to necessarily name them by name. We can just have a clause that says if there's any beneficiary that qualifies for government benefits in the future and the distribution would disqualify them from, Medicaid or other government benefits, then their share can go to a special needs trust is to prevent disqualification and provide a higher level of care. That would be the goal. So, for example, to answer that question, it's a great question.
Well, so you're mentioning different trusts, and so Ken, I part of the joy of having this podcast is we get to learn from a lot of people, and this is true in your case as well. So one of the things that sometimes I'll ask clients is what kind of trust they have when they have a special needs trust, and I'll explore with them whether it's a first party trust or a third party trust, or if they have both. And a lot of times they're not sure what it is. So can you help our listeners understand what these differences are, and how they should be thinking about the role that one or the other or both could play for them?
No, that's great. So I'll start by describing a first party special needs trust. And the first party special needs trust is a special needs trust where the creator of the trust is typically the person who has special needs. So, a common scenario would be the example I gave earlier, where the woman who had, was able to qualify for, skin cancer Medicaid benefits. She inherited money. She had money now that was in her account. She no longer qualified for Medicaid, so she created a first party special needs trust, which allowed her to get requalify for Medicaid, but there was a payback provision to the state. So that's typically the main disadvantage of creating the special needs trust if you're the one that has special needs. A third party special needs trust is a trust created by someone who does not typically have special needs for the benefit of someone with special needs. So typically the parent creating a trust, a third party special needs trust for a child. And then in that third party special needs trust category, there's kind of two subsets. One is one that's irrevocable immediately upon signing, and then it has its terms. And when you fund it or you put assets into that trust, it's there, it's funded, it's available for those special needs. The second would be a special needs trust that gets funded after, the person creating the trust passes away. And that's the most common one I get involved in because, again, we're preserving that flexibility. Once you create and fund an irrevocable trust, it's what the document says governs, and it's typically locked in, for the rest of the life of the beneficiary. So the special needs trust that gets funded after the person passes away provides a lot more flexibility. So let's just say let's say I'm a millionaire and I've got a son who has special needs and they're on government benefits. There's nothing to stop me from kind of serving in that somewhat quasi trustee role where if they need something, I can take them on vacation. I can buy them, PlayStation, whatever it is. But if I pass away, I don't want to just get them outright money. So I want to have so I have flexibility while I'm alive, but then after I pass away, then basically there's a succession there for the responsible person who's going to be then stepping in to provide for that special needs beneficiary. And that's the structure I usually get involved in, if at all possible. Sometimes people inherit money or there's personal injury damages, and they have to have, they have to set it up themselves because it's their money. But those are the main differences.
So on that basis,
person creating it has special needs. Yes.
So on that basis, it sounds to me like you would say, wherever possible, discourage the use of the first party trust, or are you saying that each can play a role, but don't go without the third party?
Yeah, I would say generally, if you can do a third party special needs trust, that's the one we try to obtain. Sometimes you can't. Sometimes the person already has money and they get injured and the money was already in their name. The general rule is the government's going to look to spend that down. But there are additional planning strategies where they can create that first party special needs trust to save assets and qualify for benefits a lot sooner, oftentimes immediately, and then preserve the assets they do have with a payback. If the sooner you can get benefits, the better, the longer your assets last. So that's the idea behind the first party special needs trust.
Right.
Yeah, I mean, that's all great points you're bringing up, and just this aspect of planning. And we just mentioned it in some of our previous podcasts. When it comes to planning, the sooner you get started, there's no better day to start than yesterday. Is that kind of similar when it comes to this estate planning process? Just to get started as soon as possible, or are there certain stages that people get into where it's a good time where they begin this process, or is it just like the cliche quote that we always use, just plan today, just get started as soon as possible?
Let me answer that. So my take on that is the time to do planning is before you become incapacitated or pass away. So that's really when you need to do it, right before you become incapacitated or pass away. The problem is that we don't know when that's going to happen, right? So obviously there's some urgency. It's usually less urgent for a 20-year-old than it is for an 85-year-old, obviously statistically. But I would say, it's good to think about this stuff. It's good to start the conversation. Be educated, because how the rules apply to a particular person vary based on what they have. Is there estate tax issues? Are there special needs issues? What kind of special needs? What kind of distributions? So I think the wise approach is to get it looked at, if there's no charge, to get some advice to learn how the rules apply. And then you can at least start thinking about it. There shouldn't be any pressure to get the plan done, but they should be educated so that they know kind of the issues at play and they can start thinking about maybe who would be the best person to do it. And if it takes a year or 2 or 3 years, and then it gets done. If it takes 10 years and it gets done, that's better than it never getting done. And procrastination is definitely the enemy in estate planning. So special needs planning for sure.
And also maybe going off that as well, let's just say you get started on this plan earlier, and just the degree of control you want to have and flexibility you want to have is going to change over time. So I guess my kind of thought process with this is just once you're in a stage where you have this like wealth accumulated, you have kind of an idea how you want these assets to be distributed and who you want to be taken care of on this aspect of it. Just whatever plan you may have in place, if you maybe have some degree of control and you want that to get changed, I'm sure you maybe have some aspects or some clients where they're, changing their plan maybe constantly, or some people just have this set in place and later on down the road, they want to update it. How do you kind of work with people with that process as well?
Yeah, that's another great question. So I would say that there usually comes a point where someone does not want to manage their own assets anymore. Usually most people maybe hold on to it maybe longer than they should sometimes. But I would say that there's usually a time, in someone's life where it's probably not good. And when sometimes there's early onset dementia, sometimes there's other mental incapacitation issues that present themselves. The legal rule is once a doctor says you're not able to manage your finances, you can't, most of the time it's one doctor saying that you're not able to be trustee anymore. You're not able to manage your finances. That's when you would either need a guardianship or an agent that you would appoint under a power of attorney. So, most people, I actually had the privilege of listening. I don't know if you guys have heard of John Maxwell. He's a leadership author. I heard him speak at the Kingdom Advisors Conference. Yeah. And, he said that most people that own businesses or most people that have control over things, they hold on to that too long. They should actually they should actually practice giving it away sooner, so to give other people practice for what that would look like. And I totally agree with that. I think that's really good advice. Just, test people in small doses. Hey, here's, maybe you create a special needs trust, and maybe instead of funding it with $1 million, maybe you fund it with 10,000 to let, the next trustee in line get some practice with what that would look like to prepare them, and see how they do. And if they don't do well, then you could always explore other options.
Oh, that's really interesting. I mean, that's great to hear about that. Yeah, thanks for sharing that.
Absolutely.
Roshan, I got a question, but if you've got something, go ahead.
No, please.
Okay, so it's about contingencies. So, Ken, in our work as financial planners, we're always trying to ask the what if questions. What if things don't go quite as well as was planned? The markets don't behave as we would like them to. Inflation doesn't work the way we'd like it to. You get disabled. Someone in your important in the family passes away prematurely. You have long-term care, whatever the case might be. In special needs planning, what are some of the contingencies that recurrently people, or for whatever reasons, they aren't taking into account? And really, if they were kind of aware of how the progression of these things sometimes goes, their plan would include some optionality in anticipation of some of these contingencies.
Can you say that a little differently?
So
I'm not sure I
let's say
understand the question.
someone
Thank you.
starts out and they are 20 years old, and they've been for whether there's a cognitive challenge or there's some sort of physical challenge. They start out at a certain place, but there's nothing necessarily that's a mortality limitation for them, and they may have 50 years. There's a lot that could change over those 50 years. What kind of plan would you want to put in place using special needs planning that could at least anticipate or flex with those different changes that person? Yeah, no, not at all. That could change or flex with some of the things that 20-year-old might face over the course of the next 50 to 60, 70 years of his or her life.
Yeah. So I think the first question would be, are they able to work for at least 5 years? Maybe if they've worked almost 60 months, maybe encourage them to work into the 5 years so they could qualify for some benefits. I would also strongly recommend to everyone to execute powers of attorney. That way, if there is an event that changes the capacity, there's no guardianship court case. Typically, that would need to be required otherwise. And you can choose when it's effective. Most powers of attorney are effective upon incapacitation. And then you can choose the person that you trust the most to basically advocate for you. And, if you are incapacitated, you can't sign checks anymore. You can't sign things. Most 20-year-olds aren't. Now, if there's a medical condition, I would say there may be a bunch of other factors like probate, asset protection, estate taxes. Get those looked at. Meet with someone, get them looked at, and then keep an eye on it every 5 or 10 years as situations change. Maybe there's an inheritance event. Just keeping an eye on it because the rules are ever changing. So, get some advice and then have it looked at, every 5 to 10 years, or if the situation changes with assets or family.
Okay. Roshan or Adrian?
I actually do have one, Ken, and this may not be specific to special needs, but with the sunset provision coming up in 2026 and after 2025, I am coming across some people that say, well, I'm below the $11 million number now, but I don't know that I'll be below the number for the exclusion for how much they can pass on to their heirs without federal estate tax. So they're leaning towards waiting to plan. What would your response be to that, knowing that planning sooner versus later is what you had mentioned when Adrian asked this question?
Yeah. So I would say I wouldn't not do planning. I would not do planning just because of an estate tax exemption is expiring soon. There are a lot of issues that get covered with planning, and only one of them is the estate tax issue. So, but if the only issue to them is estate taxes, that's usually not the only issue. But if that was the only issue, I would say that, many states have a separate state estate tax, that that clients aren't aware of. Get that looked at, and also, be aware that the laws just because it's going to exempt, and the exemption will get reduced probably somewhere in the $6 million range, it's very possible that the estate tax law will change again. It's an ever change. The estate tax has actually changed less in recent years than it has, maybe 5 years ago. It was changing much more frequently. So it seems to be changing less, and the legislators seem to be going more after income tax and retirement accounts. But if it's just an estate tax issue, there are strategies, some very simple and very easy, and some very complex and very expensive, in order to eliminate, the state estate tax and the federal estate tax issues. So, did that answer your question?
It did, yes.
Okay, thank you.
Thank you.
And Ken, you've already touched on a lot of this throughout the conversation so far today, but I think about the way in which special needs planning does or does not integrate well into estate planning and also into elder law. And so what are some of the overlaps, or at least the ways in which our listeners, if they're thinking, I have this loved one, I should probably do some special needs planning, how should they be enlarging their thinking about that that process to include some of these other areas like estate planning and elder law, or is it something that you can do in a more focused way?
I would say that, generally speaking, if somebody has assets, they should be thinking about all of the issues: elder law, special needs planning, estate planning, because all those issues may affect them. I think it was Genworth, or one of the long-term care insurance companies, did some research a few years ago that I had read, and they said if you're over 65, and you're married, there's about a 70% chance that you're going to need long-term care, and if you need long-term care, oftentimes that ends up in a skilled nursing facility. It can be $30,000 a month, in costs, and there are strategies. So I'll kind of talk a little bit about elder law. A little bit different. It's a little different than special needs planning. Elder law is typically, as people get older, they may qualify for a different kind of Medicaid where the state pays for your skilled nursing once you've spent your assets down. And there are exceptions to that because there's different kinds of Medicaid benefits. But in the elder law context, Medicaid will pay for your care, provided that you basically have less than $2,000. If you're married, your spouse, if she's living in the house still, she can generally keep the house. Generally, the spouse can have about $109,000 in assets. If you're not married, you generally have to spend your assets down to $2,000. And your house is exempt, but once you're not able to be in your house anymore, then Medicaid usually looks to that as an available resource and looks to have that sold so that it can pay for care. And so in the elder law sense, it's usually thinking about the risk of long-term care being a substantial risk, and how the client wants to plan for that, or at least be educated about the rules, because there are many strategies. One strategy is the do nothing approach and invest the money and let it grow, create a financial plan. That's a really great strategy, for people who are maybe a higher net worth. If somebody has less assets, maybe, another option, and really regardless of the asset limits, another option to consider would be purchasing long-term care insurance. And there's all sorts of different kinds of long-term care insurance. There's pure long-term care insurance. There's hybrid models with life insurance, where if you don't end up needing long-term care, there's a return of the premiums, to the beneficiary, usually 100% return of premiums, all sorts of different kinds, indemnification model, reimbursement model. And then there's also the Medicaid planning in a lawyer's office, where someone might come in and say, my mom and dad are now in long-term care at skilled nursing. It's $20,000 a month. Let's say they have $500,000. It's going to be gone in a few, 2-3 years. So in that scenario, assuming they're just on a very aggressive spend down, there are other strategies where you can do strategic gifting, sometimes to Medicaid trusts, where you strategize, because you can actually gift, and you can actually typically save about half of the assets. With the kind of wait and see long-term care planning, as I mentioned. Definitely spending half is not as good as doing the other planning. But if we get to that situation, oftentimes people do actually spend down, the assets when they could have saved half with proper planning, Medicaid planning, where the problem is that it's complicated, and the penalty for the gift is usually dependent on the particular facility that they're receiving care. But it is something that for somebody with $500,000, assuming they need 4 years of care, all of it being spent down versus the damage control planning, I call it, can oftentimes save by gifting maybe half the assets, and then the penalty for the gift can be put into some sort of a structure that pays out and pays for the care, which usually satisfies the Medicaid requirements. And then working with someone who understands those rules to structure the numbers and apply for Medicaid is usually critical. So that's the elder law. The other elder law issue is guardianship court, making sure that their assets aren't, guardianship has a cost. That cost can usually be avoided with, a power of attorney for property, for finances, and the power of attorney for healthcare, for medical decisions, where you name a trusted agent. And that's typically the two most important issues with elder law is avoiding guardianship and avoiding the Medicaid spend down, or at least having a conversation with the client about how important it is that they preserve their assets for their next generation or the charities of their choice, or their friends, their loved ones, if you will.
And Ken, I'm going to steal Erik's question verbatim right now and ask you one. The last one on there is, what have been some of the biggest joys you've seen surrounding good special needs planning?
Well, I would say one of the biggest joys I've seen is when it works well, when they've created a plan, they got good advice, and the person who receives benefits, they were getting help from the family. They didn't lose the help from the family. They were able to have a structure where it worked out. It goes on for years. I'm actually the trustee of a trust right now where there's a special needs beneficiary, and it's a really good structure because there's someone they can call if they feel like they need additional help and the benefits aren't enough. It's just really, really powerful to see the benefits play out over decades for the life of the beneficiary. They felt as though, I've received many thanks. I've seen beneficiaries, especially these beneficiaries, say, "Thank you so much, for this structure. This saved a lot of headaches. I know that I'm going to be well taken care of now." And that to me is a really big joy, just seeing the beneficiary know that there's funds set aside for them where they can receive additional benefits in addition to the benefits provided by the state or the particular government entity.
Excellent. Gentlemen, do you have anything to add?
Adrian?
I don't, but thanks for sharing that story. That sounded like it was really great.
Yeah.
Thank
So,
you.
Ken, I want to thank you so much for coming in and giving us all this time this morning to help our listeners with this area. Listeners, I want to let you know how you can reach Ken if you have further questions or want to schedule one of these follow-ups. So, first of all, let me just give you Ken's email address, then the phone number, and then also we'll offer the website. So, Ken is at Piercy and Associates. So you'll put Kenneth, full name Kenneth, at Piercy. Let me spell that for you. It's Piercey, associates.com. So Kenneth at pierceyassociates.com. Then also, if you want to reach out by phone, it's 224-848-4645. And if you want to, let me just repeat that, 224-848-4645. And if you want to go to the website, you can go to www.pierceyassociates.com. So, Ken, also, are you on Twitter? Are you on, where are you active on any social media outlets? If so, how would people follow you there?
That's a great question. Piercy and Associates has a Facebook page. I don't believe we have a Twitter account.
Okay.
Most of the time, it's going to be, if someone wants to get a hold of me, it's going to be to call my office or email me.
All right. Fantastic.
That's the best way.
Fantastic.
Appreciate that, though.
So, yes. And then if you're going, Erik, I was driving, I didn't get that down. Great. Go to our webpage, which is retirementlifestyleshow.com. Track down the episode, look in the show notes. Ken's contact information will be there as well. And speaking of the show, if you're looking ahead to next week, in light of a lot of the recent market volatility, we're going to be talking about that subject. So stay tuned next week to hear more about that. Roshan or Adrian, anything more?
Adrian, please, if you've got anything.
I'm all set, Ken. Again, it was great having you on the show, and really thank you for sharing some of those stories to our listeners today. I'm sure they're really going to enjoy it and really appreciate it.
Thank you very much for the opportunity. It was very nice speaking with you guys today.
Yeah, Ken, as echoing Adrian, thanks for joining us. And as Erik said, you can go to the website or check out the show notes for how to reach out to Ken. This has been another episode of the Retirement Lifestyle Show. Please like, subscribe, give us 5 stars, tell your friends and family about us, and we'll be back next week to talk to you about market volatility.